Hello, YouTube, America, whomever. Been doing some research this morning on some statutes at large. Reading, you know, case law, Supreme Court case law. Ran across something that I thought I'd look up. Well, I tried looking it up in several areas. I kept finding that it was a private law. Private. Well, I wound up finding it in statutes at large. And I'm just going to show you. Statutes at large do apply. They quote them all the time in federal courts. They do apply. This is what limits your circuit and district courts. So let's get started. This was actually, it starts on page 433 in the statutes at large. It's 25 statutes at large. It's from the 50th Congress from August 13th, 1888. Okay, you can find this on page 434, which is actually, when you get the PDF, you look it up at the PDF down here, it's actually like 481 in the PDF. So let's get started. It says, nor shall any circuit or district court have cognizance. Well, cognizance means it can't take jurisdiction. So there is no jurisdiction in the circuit or district courts to recover any contents of a promissory note or other chosen action in favor of any assignee. Now, assignee means the receiver of the assignment of rights, which means they are the state, or of any subsequent holder, which is State Child Support Agency, if such instrument be payable to the bearer, which is the holder, state agency, or bank, because they cash the promissory note. The state agency cashes it, therefore the bank is now holding it. And be not made by any corporation. So it can't be made if it's not a corporation. So you must be a corporation. The promissory note must be held by or made by a corporation. So that means you must be a corporation. Unless such suit might have been prosecuted in such court to recover the said contents if no assignment or transfer had been made. Now, this is where it gets key right here. Alright. No assignment states plainly that somebody must have signed it. Or, in other words, let me take that back. No assignment means there can't be an assignment. It's got to be between persons. No transfer. No transfer. Transfer is another key word in trafficking. I keep telling everybody it's human trafficking. Transfer. The transfer of rights. The assignment of rights is a transfer of rights. When you transfer those rights, you're talking trafficking. But I'm going to show you something else. You can take from right here and just black all this out to here and read it again, and you'll get the gist of it. No circuit court, I don't know about your state, but in my state it's First Judicial Circuit, has jurisdiction of any suit to recover the contents of any promissory note unless such suit might have been prosecuted in a court to recover the contents and no assignment or transfer was made. In other words, there is no jurisdiction. This is why they have to have an open business meeting, as 5 U.S.C. 552b plainly states. That's why they have employees. You are considered an employee of a civil service, and this is a business meeting for the civil service, and the hearing officer is the presiding officer, and you and the witness / attorney for the agency are having the argument. The presiding officer is the decision maker, but there must be two people participating in the decision. So when you consent or respond, you're going in there to participate in making a decision. That's how they get jurisdiction. That's the only way they get jurisdiction, and it's not even jurisdiction, it's an open business meeting. It's I can't say it enough. It is a fraud. There is no jurisdiction. There is no proof of fault. There is no injury in fact. There was no prosecution to recover the contents of the promissory note. In fact, the whole promissory note was brought on through fraud by omission, and for purposes of stealing your identity and obtaining your credit for a loan. It's fraud. Good luck with it. Have a good day.